the Criminal Procedure Act we come to effect yesterday. We mean say the justice system will begin use the new Criminal Procedure Act. Within the inside or within the provisions that means that this act, how important it is to the justice system and how public education don't turn like for the different sectors that may involve, like the lawyers, them, the police and other one. They make we get now the studio, the coordinator of justice sector coordination Office of the Attorney General and Minister of Justice, Winner Shahid Koji, we can tell we about the thing that we don't put in place for implement the new Criminal Procedure Act. Once again, Mr. Koji, good morning and welcome to the program. Good morning, Salon.
Good morning and thanks very much, and I'm happy for that this morning.
Okay, from that report we just heard yesterday, them formally launch this one or formally inform the public say this law don't come to effect. Before we can look at the implementation and provisions, them take we listeners and viewers of Radio Democracy through the stages them will pass before we reach we say with this one now.
All right, so thank you so much, and very important question actually. Before we really get to how we get to this point, I just want to reflect a little bit on how we really get first the Criminal Procedure Act of 1965. So that I think people will really appreciate coming from 1965 and then 2024. So, say Sierra Leone gained independence in 1961. So just after independence, post-era, the nation decides, well, we get laws then where they govern a criminal system. If somebody come in contact with the law, you get charged on criminal matters, waiting at the procedures that the courts for follow. So post-colonial era, the country decides, well, make we come consolidate then laws here and make we amend them so that we'll get laws that we go handle criminal matters. And now that make just after 1961, in 1965, 4 years, as you can imagine, Sierra Leone develop or consolidate this law into the Criminal Procedure Act. So this Criminal Procedure Act of 1965, basically, now it don't be the law where they govern criminal procedure in this country, and it divided into different components. The 1965 Act, you get general provisions, how for do summary trials, how for do preliminary investigations, and the powers of the courts for do trials, and also how for execute sentences. Now this we don't be with law in terms of how for handle criminal proceedings up to the 15th Monday. Now this we don't get Sierra Leone as a central procedural instrument. As imperfect as it was, we only get, now we don't use. But then coming forward, think about it, 1965 to now, we talk about close to 60 years. A lot of things don't change. And once they begin use the law, people notice some areas then go need for the reform. So a lot of advocacy efforts be done there for make we reform the Criminal Procedure Act. So some people, for instance, say the acts not really they serve in purpose. Some of the criticism will come. Some people say, actually they provide adequately for the poor and vulnerable. So for instance, some of the offenses then can say be clear enough and meets the challenges of modern time. And 60 years ago, some of the criminal offenses they commit, not to the nowadays, and then also some of the trial processes. And as the world they improve technology and everything, so a lot of advocacy efforts be done today over time for make we review so that we go match up to the current trend. So this be done they go on. They also criticize the 1965 Act, for instance. There is one provision where talks the police authorize the police for make them go arrest without warrant anybody with them fan around 6 o'clock, in the evening, or 6 o'clock in the morning if they don't or they load some side, or it in some highway, or it in a yard, it in a compound. And if you're not able to give satisfactory reason why it in at that place, or satisfactory account of himself, it give the police the right for arresting. And then when you watch this law, people say, well, basically this the targets the homeless and the poor. So some of them things really make the nation say, well, we really need for review this law. And also we be get this system where the British government be support through DFID, where be named the Justice Sector Development Program. Inside this program here, in 2006, then start to do surveys and look at the justice system in the country. Then survey reports here, one of the critical recommendations they make when they really begin look at the entire justice system. They recommend the urgent need for make we go review the Criminal Procedure Act, just for provide context on how we really be need for even, you know, take that bold step for make we review this and get a new act.
Now, you don't talk about the reasons which are we come out from the old one to this new one and the need why we need a new one. But now, take me through the processes and procedures where the justice sector go through follow we get this new one we don't come to effect as of yesterday.
Okay, so the process don't be long. I will say close to 2 decades. You know, this process we don't go on different consultation based on all the context they have to explain the need for make we change. So many sector players then say, well, we really need for do something like urgently. I'll give out that instance. We be get an Institute for Security Studies, ISS, then do a survey in 2006 as well. They print a very dark picture of the criminal justice system. They look at the police, they look at the prosecution, they look at prisons, they look at correctional services. They recommend CPA for the change. Now, out of all of this, you know, the sector say, well, I think it's about time that we really get this law. I mean, we get a new law. So now that new office come into place, you know, then after this DFID program and the Justice Sector Coordination Office develop what we call Justice Sector Strategy. Because we go for realize not so only for change one law, we change them within a framework we call the Justice Sector Strategy. So the first generation recommends a lot of do CPA, then we change the criminal procedure laws in the country. Then we now get for constitute different panels. So you get judges, you get civil society organizations, you get community leaders, you get private legal practitioners, basically the whole country come together, different people don't say, make we look at them lawyer, section by section, provision by provision, make we look waiting really go best fits. So this effort on the continue and like it starts really in 2010, 15 years we did to this point, and in recent times as well it has been concerted efforts of partners. For instance, UNDP don't deal with for support this process here. Okay. But by and large, the way we get to this point, we constitute a committee. This committee cuts across not to just lawyers, we get judges, we get the voices of religious leaders. The one they will not be even able to sit down at the panel, they send opinion papers, and the one they all be taken into consideration. So it's a complete national effort for make we review the criminal justice system.
Okay, you don't get a background of the act and also these different stages them way this act don't go through, and also you mentioned about in 2006 when I be do a survey for we actually lead to the process of reviewing the act. Again, waiting taking us so long for make now this act come into play.
Right, so that's a good question. As you can imagine, you know, for change law not easy, especially something we don't exist for that long. You get administrative bottlenecks, sometimes you get financial constraints, sometimes the people who even originate the process, they not get there again. A lot of changes can happen, governance and all that. So that really stalled the process, but now a process will not ever end. In other words, in each and every justice sector strategy where the country develop, we always don't take this process forward. It be done in phases, and not totally wipe out, because it's a long process, because we want to make provision for new criminal offenses, for instance, then cyber offenses all not be there. It be don't take a process as we go along, they review until now that we don't really get waiting we think say go serve or it go fit for purpose.
Okay. Let me look at maybe some specific areas for clarity purposes. The whole act, now the entire act on a review on a specific areas they want to look into.
So the title of the act now, the Criminal Procedure Act of 2024, now acts will repeal and replace the old act. They provide new procedures then for issues then relating to summary trial, committal proceedings, and trial on indictments, and they also provide alternative sentences. So what's it do? For answer the question, we go provision by provision, review them provision, but the current act, it takes everything into consideration, a repeal and then replace. So right through from the preliminary to the miscellaneous provisions, everything be reviewed, but the current acts basically don't replace the old acts.
The program is still listening to now. Good morning, Saloni. They come to you from the Society for Radio Democracy 98.1 FM. We bring you this edition of the program. Musa Kamara na my name.
And Adeyemi Jackson.
And we still get we studio guest. We na the coordinator na the Justice Sector Coordination Office of the Attorney General and Minister of Justice, Wina Shahid M. Koji. Today we will talk about the implementation of the new Criminal Procedure Act, we come to effect yesterday, and going forward in the country going to use the justice sector. Now we look at the provisions them where they inside. What in this new law don't change from the old one?
All right, so thank you so much again. The current Criminal Procedure Act of 2024 will take effect yesterday, the 16th of September. The act itself is divided into 8 parts. Then we get 198 sections. You compare them to the 1965 Act, divided into 6, then it gets 215 sections. Now we get sections, then like the preliminaries, they look at the commencements, we get general provisions, for instance, arrest generally, summary trials, that is the new act, and then committal proceedings. This will get a system when there be preliminary investigation. This now one major change. This we introduce waiting our committal proceedings. Then they also talk about indictments and trials and the high courts. Then also special trials, meaning how for trial then corporations or companies. Then also how for execute sentences. This also key because this new acts provide alternative sentences. And what this go do is for decriminalize the justice system, or at least for decongest the correctional services service were already overburdened. Now, on some of the key provisions, for instance, on arrest generally, the act itself, it begins by identifying under this component, say, you get for give notice of arrest in some cases. So if you come to the attention of a police officer, for instance, say some certain offense don't be committed, right? It come to a knowledge. The police officer go need for inform the Attorney General and Minister of Justice about their offenses. Yeah. So for instance, if now offense will involve loss of life, bound for notify the Attorney General and Minister of Justice. If now offense will go be punishable by life imprisonment. So so we don't remove capital punishments from we laws them. So if there is an offense to come to knowledge, say involve the punishments will be loss of life if for notify the Attorney General and Minister of Justice. If you involve public officer we allege for commit an offense in the exercise of in official duties or public duties, then also attempted murder or human trafficking. And also if you involve a member of parliament, local authority, a diplomatic or consular officer or legal practitioner. So this say you for inform the Attorney General, or also say legal practitioners then can actually commence prosecutions. And if then say they commence prosecutions, obviously they need for inform the Attorney General, Minister of Justice.
So this now before trial or before arrest?
No, this if that kind of matter come to your attention before you actually go arrest, but you have to notify the Attorney General, Minister of Justice.
If in a situation of emergency, this person want escape justice, for instance.
Okay, so waiting the act, the procedures then where it also lay procedures then for arrest, how you go even arrest first. So say the police, for instance, obviously if they don't commit an offense before or they don't allege, you don't see the situation, you get the right for arrest somebody, for confine them, for even restrict them. All of this go happen. The acts no they say, the procedure no they say, go notify, it don't come to your attention, go notify the AG before you do the necessary arrest. It will defeat the purpose of really, justice reform. So the mode of arrest, they also talk about them. And it also say the police not for restrain somebody more than necessary for make it prevent the escape. It also talk about, again, the mode of arrest you ask about. So say in the cause of arrest, if the one sort of like assault a police officer, or the one obstructs, if police one really arrest somebody, then they try for assault the police officer, or then try for obstruct her. If the police call a private citizen, that private citizen will go assist the police in that arrest. Then it also give powers for search somebody, but again not just ordinary police. You say the rank of superintendent can search somebody. And they also talk about, again, under arrest, again, this is also key. It say these are one of the key things that the Act also recognize. It say when you arrest somebody now, you for bring and come before the court without delay. When you think about the 1965 Act, it make provision say if you arrest somebody for an offense, wait for carry, life imprisonment or whatever, if you arrest somebody for an offense, you for bring and come to the courts, we get rights for listening to that matter as soon as possible. This new Act, they say, if you arrest somebody for an offense we probably go carry life imprisonment, something like murder, then aggravated robbery or treason or economic and environmental offenses, it say within 10 days of that arrest you for bring and come to the courts. Now you don't see the first one give that discretion. Now we don't try for because say the accused self gets rights, and also 10 days, within 10 days as you arrest that person, the first act be very quiet on this. So now some of them I say also other offenses within 72 hours if you actually bring them before the courts. Okay. So all of this now go allow you for just keep somebody endlessly, and now some of them say are the new act. We will continue as we go, but these are some of the things, and also alternative sentences, we will also take them up.
The issue of bail don't be of concern to many now the justice sector, and many people don't raise concern as to how the court system don't they give bail, and the processes at which somebody able for fulfill them bail, and they in this new act within the new Criminal Procedure Act of 2024 say with regard granting bail and the processes at which somebody can get bail.
Okay, so bail also a very important part of the criminal justice system, right? It don't identify certain offenses. If a punishable by life imprisonment, or economic, it possible for make the grant bail unless with the permission of a court and a judge will grant bail. For other offenses, it's bailable. And police also can grant bail, provided they go to the court recognizance, you commit, say, like you go show up if they need you, and then also if certain conditions therefore be met. For instance, if you need for handover, you documents, traveling documents as a sort of a safety. If you need for get surety, for stand in your stead. But all of this is addressed in the new act. Yes. In
the area of the police for give bail, did they ask or this law require for let person pay money in a police station for bail?
No, in our state says somebody for pay money for bail. You get conditions where you go meet now police station.
What are the conditions? Yeah.
So, for instance, if you get a police officer of the man a police station or police post, it gets a right for make it go grant bail to somebody on the condition that when the court summon you, you for show up. Again, depends on the offense. Minor. If the court ask you, you for show up. If it go to that point in which you need for give you traveling documents, it make provision say you go hand over these traveling documents, or you go give surety.
In a situation somebody go to police, for instance, riots happen in an area, police can take people and gather everybody, go with them. At the end of the day, them fair not say I need for pay money for bail that person day at the end of the day.
No, again I will emphasize the act no state say police for take money for bail. It talks within a specific period. It depends on the offense. Again, if somebody come in contact, the police go get the rights for commit that person to a bail, and absolutely that bail not free. Puts any charge on them.
In the case person pay, what's in the repercussion under this new law?
So the law they set down procedures. Then it don't say this not for happen. This is the law. And say the police then gets their own disciplinary system, and are really waiting that this the whole justice system they look at, and also on a rule. If somebody gets an issue and also they try to raise awareness on their matter if somebody come in contact with that kind of situation you get the right to take them up with the leadership of the police and then go address them adequately. But waiting basically the procedure don't lay, now that make we call it criminal procedure, don't lay out waiting for happen. And also now now, as you even report, the police don't they get training on the Criminal Procedure Act so that they go know exactly, and all other sector and players are also getting the sort of awareness raising so that everybody go know what's in the happen and how to hold somebody accountable.
Well, inside the studio now, I want to welcome we other studio guests. We now Charles Israel, we now legal practitioner. I mean, they can't tell we what he make up of this new Criminal Procedure Act and what you think say the changes that we think will bring to the legal system. Good morning and welcome to the program.
Good morning,
Mr. Israel.
Thank you so much.
Today we topic of discussion now the new Criminal Procedure Act. You a legal practitioner. What you make up of this act first of all?
Well, firstly, I want to say thank you to the government of Salone because it's been really a long time from 1965. Although yes, we don't get smaller amendments along the way of the act, but this particular 2024 act don't repeal, like don't change completely the old Criminal Procedure Act. So we tell government thank you, the executive, of course, the judiciary, and also the legislature. All of the arms of government here work very, very hard with other people and also in society. We put hand together for make this act come. Make you always say there is no perfect system. So even this new Criminal Procedure Act getting them way sometimes somebody go question or we not go fall so safe we think somebody in your opinion, but the truth is that the 1965 Criminal Procedure Act actually be need for get a review because times they change, and as my brother previously say, technology self don't come into play, and we've been still in 1965 whilst we are in 2025, so we welcome this new act. We just hope say in as much as we go look up to other aspects of the act, maybe in the future for also be amended, but this way we don't get for now. We need for understand them, understand the implications, make we fumble themselves know within this new act say how it will help, within people that will be usually they call accused persons, now they are defendants, whether that change of name they get anything for do per se. But yes, we acknowledge this new act, we tell government thank you, and of course we interested also for ensure say people understand waiting they. I know say me brother don't talk about certain provisions.
Yeah, because that my next question. We can look at how as private practitioners go contribute in terms of educating the public about this new act. You're not a private legal practitioner, and already the new Criminal Procedure Act of 2024 don't come into being. Let's look at the provisions and the new changes them inside this act. Waiting as private practitioner, or you in particular, think of some of the provisions or the changes them we don't do inside the new act.
Okay, so the act wide, although this is better in terms of number of sections and all of that as compared to the previous one, but the issues are many, so I'll just pick and choose as a comment on this question. I think say the aspect of detention, first term, if not felonious matter, police they investigate, then get the authority for keep you for 10 days and no more. Although over time we see how police abuse that one day. Well, the self can say there's no some investigation and they will need time. But the law not the law. If the law said 10 days, then it has to be 10 days. Because if you cannot investigate within 10 days, then you for put the person on bail. But police been get issues with that. Don't see people hold on in a police detention, then 3 months, 4 months, as the case may be. Now the difference between that one and this now, this new CPS say if police find out say they need for hold somebody in detention more than 10 days, they need for go to court and ask the judge say bo extend with time not more than 15 days additional.
Even before the start of this trial?
Yes, this is now at police station. This is police station, not trial now. When you dey in police custody, then they investigate you for know if they for charge this case. The law say 10 days. If na serious matter, we can call felonious. But if police now notice say this 10 days not go do because of the nature of the investigation, then they go court for an extension. Now, wetin this mean basically na that instead of waiting be the happen to the way police go hold you more than 10 days, and that is illegal, except to be in a good court for challenge that decision day, and you can find out say police can rush just for meet up that 10 days because no provision of been there as to well what to go do if the 10 days expire. So then sometimes can rush and charge the person, but the safeguard then turn and have been that put them on bail whilst you continue. But some people, they really police can afraid for put them on bail, so then they get that. But now this one say go court, ask court for extension, so the court can extend for further 15 days for allow the police conclude this investigation and charge the matter if they for do so. So that's the issue there. Now with regards to this issue of arrest, this new CPA, it says something very important, and I think say farm will also for know. Now that section 4, the subsection 5, it say if police want for arrest or go for arrest and see say difficulty there, they can ask you as a private citizen for help. Now, whether that help constitute an offense if you refuse, that's something for discussion. But in subsection 5, it say this private individual shall go to assist the police. However, if you resist police arrest, then police will use within the act they refer to as sufficient force. However, this act say that sufficient force they enough for amount to death, enough for lead to death. But so we fumble for no say for resist police arrest. Once the police tell you say then they arrest you, you cannot resist. And you, the private individual, if you are asked to say come assist, follow arrest person, if you deny, would it amount to an offense?
I take you back to one incident where I met recently in the U building. We say police don't put a checkpoint that they check everybody. If you get national ID card, no matter the ID card we get, they enter U building. And one guy, they try for tell them, me as staff now this place, the police, they say, if you talk, would they arrest you, would they handcuff you just now? What in the situation say in terms of issues like this or situations like this without warrant of arrest, police want for arrest you or meet you on the way, break you for search?
Okay, so generally police get the mandate for ensure say them prevent crime and also help for protect life and property. So if the police reasonably suspect say something not okay, then can do search. Okay, then sometimes you can find out say police can just go to a particular place and launch out to checkpoints and search vehicles, and okay, that's okay. What is not okay is that we don't have any law in Sierra Leone where say you for waka with your national ID card. We don't have that law. So if somebody not get a national ID card with them, the police cannot prevent that person from accessing, services as the case may be. Because U building is a place where the public they access services. There are a lot of ministries there, so somebody get reason why one go there. So if you say you they prevent somebody from accessing a public space because he no work out with a national ID card or he no get national ID card, then we don't have that law in Sierra Leone. Okay. So for me, it could be that the police they act beyond the authority. However, as I say, the police get right for check.
Okay. Continue for stay with me inside the program, Mr. Israel. We come in a legal practitioner. They talk about they making your input into the new CPA Act. I come to the coordination, the sector coordinator, justice sector coordination office of the Attorney General Minister of Justice when Shahid M. Koji. You don't do the program, you don't listen to a legal practitioner, a private legal practitioner, then I then get for go court and stand and argue for clients them. But one popular side now this or provision now this new CPA Act maybe they make the rounds the time with this law being they pass now the issue of jury. Take me through this jury system, within that advantage and within that disadvantage where they don't pull under the CPA.
Right, so thank you so much, and I actually welcome you, Boda, for adding voice to this discussion, because as you say, the law is quite wide, and also interest. I mean, the car say in the introductory when they develop this Criminal Procedure Act, not a government's work. Our government lead that process in the Office of the Attorney General Minister of Justice, but we involve everybody, so we involve private legal practitioners as well. We get heads of chambers, we represented, we get a bar association. I mean, it was all inclusive. And as it is with law, you know, it always subject to interpretation and all that. So then discussion always will come up. Now, one of the key things where the law really, this new Criminal Procedure Act of 2024, deal with the issue of jury trial. You know, for understand back, you know, say we get this capital punishment, you know, now we law book, and death penalty that has been abolished. So now we want to thank the jurors then for all what they don't do, because what they don't do before national service, but I hastily make a known say the jury trial system is gone. The new Criminal Procedure Act not provide for jury trial. Absolutely. Even in UK and other Commonwealth countries, they don't actually move. Quite recently, UK, they conduct a study, and then they recommend the jury system for be abolished. There are challenges as much as there are advantages of the jury system. It's always open to debate. So jurors then, for instance, we don't get instances in which it will really difficult for make you get people then for come forward for serve as jurors then. So what thing that happen is you will get the same set of people that they will sit on the same trial or different trials, that we will get the same set of people for address some of them trials here. Then also it be actually difficult for manage and absolutely expensive. Now, when you watch, it be also responsible to a very large extent for delay in executing the justice system. If you get, for instance, a juror where constitutes of 12 jurors, a panel of 12 jurors, 3 no day, basically it delay the process. What that would do is you therefore empanel another jury for make them sit down. And once that's happened, the accused person in rights go don't be trampled upon. So you therefore protect that. These are all some of the challenges of the jury system. Then also, obviously, the jurors that they really sit on matters on you know where they carry death penalty. Death penalty has been removed from our books. Okay. We get now life imprisonment if you commit an offense way punishable. I mean capital offense. I mean now if it is a very serious felonious offense now life imprisonment. So we don't actually need the jurors there again for seats on that, but what's not happen with the elimination of the jury trial system? They don't get assessors then. The assessors, they are now a judge alone, but the assessors then go sit down for aid the process, for contribute to the judge. The judge go listen to the part, but the decision ultimately na the judge in. And the assessors, they are not so just ordinary people there. So waiting we don't do, or waiting they act pretty much do, for cutting down and for make sure say justice is expedited hastily or quickly, then assessors and people that will get speciality on matter before the courts. So if now criminal or financial matters, the jurors then will look at jurors, they will get competence in financial matters. If now medical issues, I mean basically then come with people that have experience in those matters, and then go assist the judge for sit on them things here, on the matter here. And also now, you know, instead of all of these delays, some jurors, they're not there again, you know, we're not able to track them. The jury trial has been eliminated. But I will also say, even before we get to this point, there was a national debate. Even amongst the committee members there, they get a lot of discussion around this. And as it is right now, it is what it is in the law, you know, before we get jury trial. Now it is not there.
Okay.
And this is the current law.
The jurors or the jury system not there na the new act anymore, but we talk about the assessors where the acts make provisions for. One go say not just the name change.
No, it's not a name change. So now, something very specific. The jurors then can go, after the lawyers, they don't present the arguments, maybe the prosecution, the defense, then listen, the judge provide the guidance. They can come with a verdict. That verdict, basically, the courts go follow. With the assessors then, now judge alone they sit, but then they assist. And now people that will get expertise.
But they sit
on
together
the
with the judge.
Yes, then go sit for assist. Now then go help on matters before them, we then get competence in. So ultimately the decision will be made by the judge, but most certainly it will listen to the jurors then. So there is a stark difference between the two sets.
Okay, for listeners out there, perhaps when you talk, many at the studio go understand, but for the layman out there, when you talk of assessors, you can able for Bugaikan down as to who that now them people here, so who that you refer to.
So the office of the AG they move for make we do, and the coordination office for make we really speak justice issues then, so that everybody go understand. So as much as possible, it's because again when you think about it, why make people that they even avoid on the doubts the justice system, the languages that can be very specific, people don't really understand. That make we get out in communications, you need that awareness raising, and quite recently we don't start some programs that for creating same awareness. Now the assessors, not just Sierra Leoneans, right? Sierra Leoneans will get knowledge in specific matters. So for instance, if there is a matter on media, Musa na media guru, Adeyemi na media guru, you could be a juror on that particular matter. I mean, you could be an assessor. So these are Sierra Leoneans then, but then therefore get competence on the matter before the courts.
But who that they identify or pick that set of people here?
Well, actually, now the judiciary is the justice system go watch say again for the act say, make I just make this again this point. The act say when then choose an assessor, right? An accused person get the rights for say I don't want this person there for be an assessor. And if you provide really reasonable reason, that person they then can take them out.
What are the difference between the functions juror and assessor?
The assessors then, to start with, both sets of people then are Sierra Leoneans then of normal, like when they say let you peers then try you. If you want to discuss footballing matters, you want people and we get experience in football. Most certainly, you know, and discuss, you're not going to be too okay, they discuss football, then you go come with somebody who is so good in farming. It's a mismatch, right? So the jurors then they don't be different people in our communities. And also, it's like for exclude certain sets of people then. Because, for instance, if you take me brother, we get legal knowledge, you put as a juror, it's not going to happen. Because, you know, in choices or the use of a vocabulary, you go be informed by a knowledge. And that. So they take ordinary people then, we go look at matter from a common sense point of view. Right? And this not just even globally, they look at people then, how they go reason. For instance, if you need something for identify somebody in age, a juror, normal person like me and you go watch say, but this person I wouldn't say na 7, they are common man. This person are 25, not possible. The assessors now they are still Sierra Leoneans, but in this matter now, then go basically choose people that like I say we get competence on the issue before the court.
So the difference if I get that the jurors that be ordinary people we then can pick up, and the assessors are experts in their fields. That's the case.
Both ordinary, yes, well, that can be some difference. Both ordinary, but for the trials then now, you know, why make we streamline them? Because if you take, for instance, you don't pull 6, 10, 12 or 13 people then out, right? People then wait for go come with a verdict. Now you don't come with people for aid a judge. If you don't count people for aid the judge on the matter, you count people that will get knowledge on that specific issue before
the assessors they're required in any case, in every case, on a specific cases.
Well, the provisions say now a judge alone, but with in some instances, then can get the aid of an assessor. So they are not required in every case. It's really a judge alone.
Okay. Council Charlie Israel, we in a legal practitioner, private legal practitioners, replacing jurors and assessors.
Well, yeah, I mean, the juror systems have been getting on advantages So we cannot throw that away. But since we don't move on now to the new system, judge alone or judge and assessor, we cannot cry over spilt milk. So the difference here is that the juror system, now the juror, now then they make the decision as to whether you're guilty or not guilty, after the judge don't give them direction with regards to waiting at the legal position. With the assessors, they don't make decision as to guilty or not guilty. What they do, they give the judge an advice on that subject matter. The county board say based on the specialty. So now the judge, based on the assessors, their advice or opinion, go make a determination of the matter whether there is guilty or not guilty.
What are the impact of this Criminal Procedure Act, the new one, on a job, or in terms of whether positive or negative?
It get a whole lot of impact. Some of the impact we're not going to see them now because they are long term. Now until we begin for role in practice, that is when we begin to see the impact of some of these things. Like for example, the aspect where the police get for go court, for go extend somebody in time of detention. That's where you see the lawyers would have to go argue to say no, the police not get no reason for extend this time. We think say they just want for waste time and keep this person in custody. So the impact is huge, but honestly there are also good aspects for we practice as lawyers, like this issue of preliminary investigation in those days. Imagine somebody they magistrate court for murder charge, and then it takes 6 months, 1 year, or almost 2 years just on preliminary investigation, because during that trial day, that investigation day, 6, 7, 8 witnesses they come, and the defense get for cross-examine them. The court they take adjournment. Sometimes and they issue go up in the country. They say prisoner they know they come today, but now preliminary investigations, which we now recall committal proceedings, this law say na 28 days maximum before take. So if they bring you court for murder, you know say within 28 days you go don't know if you go high court or the magistrate go discharge your case.
Okay.
You see, so I mean it's also good for we, because as in we practice, if case stay na you earn, also they affect other case there.
Continue for the program in name Charlie Israel Williams, in a private legal practitioner. They give in own opinion but the new Criminal Procedure Act of 2024, where now they use the court system, and also we get inside the programs Shahid Koji, when the coordinator Justice Sector Coordination Office of the Attorney General Minister of Justice. The program where they listen to now Good Morning Salone, and they come to you from the Society for Radio Democracy 98.1 FM. Well, from that material there we come now to we studio guest them and come to Shahid Koji, Coordinator Justice Sector Coordination Office of the Attorney General Minister of Justice. Mr. Koji, the new acts make provision for alternative or suspended sentences. This, I believe, now a new provision, a new introduction of the sentencing procedure into the justice sector. For listeners, them, when you talk of alternative or suspended sentencing, what does this mean? What do you know that the say?
Right, thank you so much. Good question. Now, think about the correctional service, right? Capacity 324, it gets over 1,500 inmates. So it's already overburdened. Now, think about other than the criminal system they affect now, ordinary Sierra Leoneans, me and you. Now, you get certain offenses somebody will commit. The courts go through a trial, then pass an imprisonment of not exceeding 2 years, then sentence you, say you don't sentence you for this offense here, but you for go down for not more than 2 years. Now, wetin this act don't do, and also for create this kind of efficient system, and it's kind of for decongest the correctional service, and also allow people to forget about their businesses when the offense is really minor, rather than those petty things you going down. So we can suspend your sentence. So we get what we call suspended sentence. At times, the courts will also defer your sentence, meaning the suspended sentence basically will tell you, say, the court will make an order. Say, we don't look at the circumstance. This offense where you commit really, you for don't go down. But because the sentence now less than 2 years, we go suspend the sentence here. But within 1 year, if you commit another offense, the court try you, then find out, say, you sentence now imprisonment, you go serve that term. So when they suspend your sentence, it mean you go able go about with your business. So you get people that way they do their petty business, no one say their livelihood. You also get deferred sentences. So basically, again, if less than 2 years, you don't basically get less than 2 years. I mean, you charge now your imprisonment term not more than 2 years. The courts can say, let us defer this person. Not mean say to convict. You are a convict, but they defer. So tell you pregnant. Okay. So this could be deferred.
Mr. Koji, when you look into the justice system, or we look into the own system as salon, we be not used to that system wherein somebody appear before the judge or magistrate, once he found guilty, sentence them and go prison. Now you talk of alternative suspended sentences, and also we don't see situation where cases that go on a court, how witnesses or accused or defense that they get clash. We are in a situation the judge or magistrate they won the parties them. How you think that this system go operate into we own operate as salon wherein both parties now will get issues?
So the system don't take effect. And also for support this implementation, a lot of training programs don't be gone. The Sierra Leone police don't conduct training. I mean, UNDP don't support some of the initiatives here. The judiciary, as you listen, the Chief Justice don't say training programs that therefore be conducted for magistrates and judges, and also the State Council and legal aid practitioners. So everybody aware, say, some offenses not mean say you for go down, because now the very thing this would try for faith, so that we not congest with correctional service, and that you allow people then forget about with the normal business. So public education, knowledge, and also the accused person, you know, they give people the free pass to go commit an offense, but a possible say you cannot go down. Sometimes they will give a community punishment order, say go clean now a public office, go clean the House of Parliament, go paint the hospital, go do some work. You're not so hardcore offender. Waiting basically the law they look at now that the only people wait for go down now really hardcore criminals. Okay. They also introduce some fines, but by and large there's a lot of training, there's a lot of advocacy. Even up to yesterday, the Attorney General McKinney, they talk about some of them things that whatever opportunity we get, I sure soon I'll be done. They see with flyers there. Even before the new acts they come into commencement, we don't they do a lot of awareness reason, because not really claim what you not get, and there's a lot of effort. Yes.
As part of the implementation side of this law, the CPA, we get cases them we been in a courts under the old law. This law don't come to effect. What think will be the status of them case here? Are they going to be tried under the new law or the old law?
Okay, so Section 198 of the law say, the New Criminal Procedure Act say, all them matter then will be done day. This law don't take effect. So going forward, every matter before the courts will be tried in accordance with the Criminal Procedure Act of 2024. It don't repeal, it don't replace the old law, and this transition don't take place since yesterday.
And that no matter the status of the case?
No, there is already, we don't transition into that, and that all matters will be tried in accordance with the new law.
Okay, make we come to Charlie Israel William, private legal practitioner, trying cases or existing cases we've been there under the old law and now trying them with the new law. What does this mean to the justice system? It get any impact on them?
Definitely get impact. As I say initially, there is no perfect system. So in as much as the new CPA come with a good package, but also it get things there, as I say, where somebody go on for critically look at and examine. This issue of the transition clause, now that waiting we been only expect initially, now that once a matter, especially trial, once a trial don't start under the old act, that trial for continue under the old act, because certain things that we go don't set up where it go difficult for you take them away once they've started. Let's say for example a particular case we don't get jurors where they sit with the judge, and now under this new CPA there is no jury trial, and if you say this new CPA for take effect, you are like saying the jurors in that case for go away, and then the case now be transformed to a judge alone. But as I say, these are all issues under the implementation now for the judiciary and the justice sector for look at and see how all of them things here go happen without adversely affect the cause of justice, okay, or the rights or privileges where defendants then get. But that is it as me brother don't read that provision 198. It say if an investigation of a case don't start under the old, when the new one come, definitely it will take over the old. So we all as practitioners therefore understand this and find a way to cope with it,
So how now they cope with the law so far? Now the implementation don't start.
Well, it's just like a day after the 16th, so we did try, but obviously, as I say, challenges then will get for on the way. It's something new. It just like where we been in school today. When them bring NPSC from selective entrance, and then midway after you don't take your selective entrance, say no exam no been there until you get to Form 5, but then they bring Bekeka, and all. So I mean, over time we go adjust. I
can't tell Mr. Koji as a roundup statement. What are you call to the public, or what are you message to the public in terms of public awareness and the implementation, a smooth implementation of the new Criminal Procedure Act?
Okay, so I go once make the public stay tuned. Now the coordination office under the direction of the Attorney General and Minister of Justice, we don't do a lot of awareness raising programs. So quite recently, we don't even introduce on national television what we call Justice Hour and Justice Sector Hour. So basically, we get for the talk on some of them things that are waiting to happen within the justice system. We organize town hall meetings, we do a lot of flyers in and out, and also we do a lot of publication like newsletters and a lot of things that for just inform people exactly on what they do.
As you talk about the public, themselves don't they follow the discussion this morning, and one Frederick Baggy in our Facebook page, they say if you have a case wherein the victim accept the crime and the relatives come in to settle the issue, it is possible for the police to keep the accused in the cell beyond 72 hours while the matter is addressed by relatives? This is a question in the ask when I Fred Baggy on our Facebook page.
This one from Amid on Facebook page say, what if the assessors are easily bribed? They can misguide the judge on the said matter. Whilst the jurors are 11 or 13 in numbers, it is difficult for them to misguide the judge because they analyze the matter based on facts.
This one from Ibrahim Sisi on our Facebook, they say, indeed, Sierra Leone has crafted many good laws, but the real challenge has always been in making them work. This new Criminal Procedure Act is a welcome step forward. We only pray it goes beyond public announcement and is fully implemented to bring real change.
This one from Mark 10 say the act outlines specific procedures for arrest, including the requirement for a warrant of notification of authority, and demand for admittance. Arrested individuals have the right to be brought before a court as soon as possible and be informed of the charges against them.
Okay, you can respond to the message here quickly from the public, and we come to Israel and close up the program.
Okay, so on the issue of, then go bribe assessors and all that, no, well, we are Sierra Leoneans, okay? The matter before the courts, they go take people that have competence, then go give their opinion, but ultimately, it will come out from a judge. Obviously, say a judge go look at the merits of the case. And yes, there's a lot of hue and cry, say implementation of laws na challenge, but waiting we don't do this criminal procedure, not just one law. Within the justice sector system, now a whole sort of reform is done within what they do broadly. So whilst the procedure don't be addressed on how to handle criminal matters, the institutions that were responsible and other sector players that were responsible are also doing their part so that this will be successful. And obviously, wrapping up, I go say somebody asked. Obviously, police then get again. If relatives that they discuss matter, not to get that question, but we get things that when alternative disputes mechanisms. Not to every matter once make even fairness set in a police system. We also get the informal justice system, how to deal with small matters then, so that it's not go clog up the court system. So all of these they happen within the justice sector reform, and all them things here. Once we put it in place, we will able and discharge justice fairly, and everybody.
So in that case of alternative dispute settling mechanism, we get on the issue at hand. We say we get chiefs them now Freetown. We people don't argue say Freetown not supposed to forget chief. What's in the justice sector say about that?
Well, if you talk about alternative dispute, basically now a way for address some issues then without going into the court system. Freetown as a municipality, I mean, we get our own laws then. People then can get an opinion, say chiefs should be here, but the laws are very clear. We get the local court acts, we basically don't demarcate who should be who therefore preside over local matters, and if matter fall within Freetown, you get the magistrate court system for deal with. But waiting we the try for do now, some of them discussions here basically we try for igniting and see the public will be much more interested, and we put into.
So in conclusion, you say chief not for the Freetown. Is that the case?
No, sir, I don't say I don't conclude. So basically, as a government official, we left the debate open. It's intriguing, and out of the discussion here, a lot of policy programs that can come in place.
Okay, I come to Charlie Israel William. I want to take a little bit from the CPA, and we see this being Justice Alloway being pulled a very long notice. They call for justice, and yesterday we see State House don't suspend Alloway. What thing that you take on a suspension as private legal practitioner?
Well, I think all waiting they happen so. In terms of processes and procedure, apart from the concern where the justice get, where we see the social media with regards the letters and all of that, I think that one is subject to investigation and all of that. So with regards to the suspension, I still think all of that is within the processes and procedure. Within the interest will be as well a private legal practitioner. Now that we go look up to how all of this go unfold until we get a conclusion. But at this stage, it is not wise at all for comment on the issues themselves. Okay, but the processes, of course, we know the judge get concerned as to the things they will consider then do against them, maybe write letters and all of that. Now we don't see the Judicial and Legal Service Commission has been asked to look into those matters. So we go wait for see how that whole investigation go and waiting the conclusion go be. But indeed that is procedural.
Okay, in the Charlie Israel William, private legal practitioner, every day inside the program for talk on the implementation of the new Criminal Procedure Act. We don't come to effect yesterday. Plenty thank you for joining us at the edition of the program, Mr. William.
Thank you so much.
And also we've been get the coordinator, Justice Sector Coordination Office of the Attorney General and Minister of Justice, Shahid M. Koji. We can tell we what did they do for implement this law and what are some of the provisions that inside this law and the impact on the justice system. Plenty thank you for joining we inside the program. Good morning, Salon.
Thank you very much.